So back on the record on the Gider versus Hubbell matter, this is on the DAS request for extension of the order of protection, is that correct? This is, we're here on your request for an extension of the order of protection.
Yes, Your Honor.
Are there any issues before we get you all sworn in?
I filed a new motion with some additional exhibits, Your Honor. I would like to.
When did you file it?
It was filed about 10 days ago.
Have you received a copy?
Yes.
Oh, let me see. Well, I need to see what you filed. Yeah, probably not, so I don't have it. Let me see your copy while the clerk looks it over. And you indicated you have received a copy, Ms. Hubbell.
Yes, sir, I have.
Is it, based on what, are the new allegations in the new petition, in the new motion, sir?
There is some new. I thought it would be good to have the criminal court document for Ms. Hubbell's probation, 2-year probation.
Yes, sir.
I present that as an exhibit. It is signed by judge and it details Ms. Hubbell's probation details.
And your response to what he submitted, ma'am? Do you
I
know-
don't really see the relevance of that. I'm not on probation. I mean, I don't see the relevance, but if he wants to let it in, I guess it's up to you.
Is it your desire to proceed today with this new information just coming in? I haven't had a chance to look at it, so.
I looked at it and I don't really think it makes much difference. I don't think it's gonna hurt my case or anything.
So, okay. But as far as what you're saying today, you are ready to proceed with him in
Yeah, if he wants to question me about that stuff, I guess that's because last time he had presented all his evidence and then we're going to me. So if he wants to ask me about that stuff and you want to let it in, I guess, we could do that. But also, I was not able to print off a copy of the, you were looking for the 2016 extension of the order protection?
Yes, ma'am.
And I found it on my computer, but I couldn't print it off. But I don't know if y'all found that in your file or if
You have a copy of that in your,
No, Your Honor, I don't have a
documentation? And that was over in Circuit, correct?
Well, it should be over here now because they sent the whole file over here. But
But the order was issued from Circuit, correct?
yes, and I don't know if I show you the first page of it, if it would help you find it.
I need a copy. I think I saw something that showed it had been submitted over here.
It was filed, it says Third Circuit Court, and it says order, and it was filed June 30, 2016. And it's only 3 pages. It's like 2 pages of writing, and then it was signed on the 3rd page. So it's just it's very short.
Are you referring to the order protection? Is that correct?
I'm referring to the first one he extended. The first time
I have one that was transferred over here from September of 2017.
That's the most recent one.
Yeah, okay.
Yeah.
I have that one. Well, I have the order that transferred.
Well, you were looking for the 2016 one and couldn't find it, but I don't guess.
But I
you
have the
need
most
it.
recent one. That's the one from September 2016. And, okay. Okay, so today, I think we are proceeding on your proof today, is that
Yeah.
correct? And of course, anything that comes up, that will be rebuttal, and I guess part of your motion will be the rebuttal too as well.
Well, I don't even want to, I like to just give my testimony. I don't really care to hear his voice and have to directly question him. I'd rather just tell you my testimony. And then if he's got any rebuttal, if he disagrees with what I say, he could say that. But, I don't really have
Well, I
a
really
whole
don't-
lot to say.
I really don't think it's really up to you to make that decision. That's a judicial decision to make. I mean, if he has a rebuttal, I mean, that's to what you present. He has a right. You have a right to
Right.
to rebut what he has presented.
Right. Right. But what I'm saying is, things that happened where we were both present in court, I would just like to give my testimony, and then, rather than me going through and asking him all these questions, I would rather just tell you my side of the story and let
Oh,
him
you
tell
saying you
his.
just want to just make a statement and not question him on the oath?
I think so.
You just want to make a statement and not question him at all?
No, I don't really have any, I don't want to ask him any questions. I just want to make my statement. And if he disagrees with something that I say, or I say something he doesn't think is correct, then I just want him to tell his side.
Without questioning you?
He can question me about what I say.
But you don't want to question him?
No.
Then I guess what I'm hearing is all you're doing is just making a closing statement then.
No, I want to tell you, I want to give some testimony. I want to give you my testimony about what happened in court. Can I not do that?
Since what's happened in court since we started this back in
No, I mean what happened in court as related to things he put into evidence against me, and what he's using as, justification for extending the order of protection for 10 years and putting Delara on it for 10 years, and the SCAG order that's the biggest problem I have is with the gag order, and I think that's the thing he's most concerned about is making sure that I don't have an opportunity to expose the truth about what's going on.
well, I mean, he has the right to question you on some of those statements that you
Oh, he can question me. I just don't care to question him, and unless he already questioned me the other day.
But that
So
was,
if I say something,
that was on his proof. Now we're starting with your proof today.
yeah, no, he can question me about my testimony. I don't have a problem with that. I just want to have this is really stressful for me, and I've been through all this stuff for so long, and I want to have the least amount of direct contact with him as I can. So I can't stop him from asking me things and answering him, but I don't want to initiate any questions. I just want to tell you what happened, and I have the documents that I would like to share with you.
All right. Let me take a minute and read what you have submitted, and I'll be right back. Okay?
you're his clerk, right?
I am.
Can you, this is what I wanna, Tanya, can you give this to him while he's doing stuff?
He'll get me kind of.
Okay. Well, you can keep it because I'm gonna, those are your copies. That's what I'm trying to get him to turn in.
Comes back at 6, you may take your seats.
All right, I've read this, and we can proceed as you requested, Ms. Hubbell. So let me get the party sworn in.
Please stand and raise your right hand. Do you swear affirm testimony you're about to give to be the truth, the whole truth, and nothing but the truth?
I didn't.
Yes, I do.
Thank you.
We're gonna start with him asking me about the new stuff he filed.
Well, no, I mean, this is your proof, so you can go proceed however you want to proceed.
Okay. Okay, I have some things I'd like to. Oh, let me turn my phone off. I forgot I didn't turn my phone off.
Yeah, please silence your phone.
Yeah, I totally forgot about it. Okay,
Let's see, did we give your copy back to you on your motion?
Yes, Your Honor.
We did. Go ahead, I'm sorry.
okay. One of the things he submitted was a list of my arrests, and I have 4 expungements here for some of those arrests that I've had over the past several years. These are 4 expungements. I have had on the border protection violation by posting on Facebook. I had 2 bench trials where I was acquitted on First Amendment grounds, and Judge Leonardo dismissed one of them at the preliminary hearing on First Amendment grounds. He said he said he knew my lawyer, and he didn't think she had advised me to post on Facebook, but he said he did not see it as a crime, and he dismissed it. So I'm just telling you the resolution of some of these arrests. And I am on probation now, not for posting on Facebook, but for going to check on my daughter at her father's house. I was not seeking to make contact with him. I was just trying to find out where my daughter was and if she was okay, because she had been subpoenaed to court twice, at least twice, and he did not bring her. And I filed emergency motions trying to get the judge, somebody to check on her, because I was concerned, and he had filed a request to move her out of state, and he has before done what he wanted and then got permission. So I did go to his house. I was doing my own welfare checks. I knew when I did, I went 4 times. Every time I went, I knew that it was a separate violation of border protection. But my daughter was my primary concern, not whether I spent 4 years in jail on, for those 4 accounts. I wanted.
Let me interrupt you real quick. It's just one question. When does your probation end?
What? Yeah.
When does your probation end?
June of 2023. And I had, because of COVID and stuff, there was like a real long delay. I had 3 charges pending. Oh, and there were 3 other arrests. There's one arrest that I was arrested at a supervised visit, and I still don't know why. I was never told why. But that was dismissed for failure to prosecute. The visitation supervisor didn't come, so that was dismissed for failure. I've been arrested like 12 times on like 9 different charges. But the 7 that were pending when I did this plea deal, there were 4 violations where I went to Dolores, check on Delora. And I didn't go into the house, I didn't break anything, I knocked on the door, I asked neighbors if they'd seen her. And the only contact I had with him was I was going to leave, and I was sitting in my car and across the street from his house, and he drove up and he sat next to me, and I said, "Where's Delara?" And he just sat there next to me. I think he was doing stuff on his phone, right next to, he was going that way, so we were like next to each other, passenger door to passenger door. And I saw the dog in the car, I didn't see my daughter, so I was, I just want to know where my daughter is and how she's doing. So I had 7 pending. I had, those 4 for going to his house, which I'm absolutely guilty of, and I'm not sorry. And I quit when they finally got DCS to make a connection with my daughter. I didn't go again because all I wanted was somebody to check on her and confirm that she was still in the state and okay. So, and before that, one of my arrests that was pending was when I went to Delara's school. She had like an open house at her new school when she went from elementary school to middle school. There was like an open house for the incoming 5th graders. And I went there to kind of get a feel for the school and to support her. I didn't know if she and her dad were coming or not. I got there first and then they came in, and that was the first time I'd laid eyes on my daughter for a year. And that was the last time I have ever laid eyes on her. That was July 29th, 2019. So that was one that was pending for violation of order of protection because I didn't consider it a violation of order of protection, but it was a charge that was pending. And another charge that was pending was one that I was really concerned about because it wasn't based on a fact, it was based on a belief. He said he believed I was at a park at the same time he was. And that really concerned me because I wasn't there. I was there the day before. I might have been there afterwards, but I was absolutely not there the day that he said I was there. And when nobody saw me, nobody heard me, I find that very concerning, and I'm really disappointed with the DA. But anyway, that was one of the ones that's gone away with my plea bargain. So so that's 2, and I don't remember what the third one was. It might have been the one where I've been arrested for posting on Facebook because they say you can't, this is the gag order in the order of protection. So if I posted, an order or and I understand not posting his name and phone number and stuff, like, I understand that. But having his name, posting something where he's making allegations against me in a legal document, when I post that legal document, I've been arrested for that. And the DA, I had one charge, and the DA tried to make me a plea deal, because I don't think that should be, illegal. But when I went to my preliminary hearing, the DA said they were really threatening me, and they're like, well, if you don't take this plea deal, we're going to go to jury trial, and we're going to have about 30 charges against you, and you can spend like 30 years in jail or whatever. And I don't like that. I don't like to be bullied. I don't like bullies. I don't like people who punish you for exercising fundamental liberties. And I do consider myself an activist and an advocate, and I stand up for what I think is right. And
Okay, let me hold. You had your hands up. This is her proof. Now, you have a right to cross-examine her when she finishes.
Okay,
Just
yeah.
hold your questions until after she
write it
finishes.
down if you need to.
Okay.
Okay, so that's about my probation. So whatever, and I'm not exactly sure what 3 it was. I know it was the going to her school, and I know it was going to the park when I wasn't even there. And then it was another one. But you see the kind of stuff he complains about me posting on Facebook. He doesn't want me telling my story. I believe I have a right to tell my story.
But in all of your commentary there, you admit you were found in violation of the order of protection, correct?
Yes, there's no question about that. There's no question that you have the authority and the right to extend this order of protection for up to 10 years, no question. I admit that. But I don't believe you should. I believe, and if you do extend the order of protection, I believe it should just be the no contact order, not the gag order. And I would like to share this Court of Appeals opinion in our case, where the Court of Appeals,
Is that this case? Is that on this case?
no, I haven't, this was from 20,
Is it on
it was
the,
the first custody, it was in Callaway's court.
but it's on this case? The Court of Appeals case that you have, it's on your case.
With the Laura,
It's on this case. I mean, not on this hearing, but it's on this case.
yes. it's
No,
this-
Your Honor, it is not on this case.
Could I just let you
Is
look
it,
at it? And
is it, okay, hold on. If you're gonna, are you passing up as an exhibit?
I would like to put this in as an exhibit.
Okay, then he needs the right to see it first before
Okay,
I see
gave
it.
to him. And he, it's his.
Your Honor,
Here.
that appeal is related to first custody order of Judge Callaway. It has nothing to do with the order of
I
protection.
understand that, but I just want to be sure that it's on this, on these proceedings, not on the order of protection. It's on,
Yes.
it's on the custody proceedings.
Well, it's mentioning restrictions on me saying his name in any way.
Okay, who filed what? Who filed? Who's the petitioner on that?
This
Okay.
is my appeal because.
Okay, but who filed the initial petition? Who filed first?
In this case, to change custody.
On this custody, on this petition that you're talking about right there?
He did.
Okay, you filed, correct?
This appeal was related to first custody case, Your Honor. And
Okay, who filed the initial custody case? That's what I'm asking. You
Yeah.
filed,
I might have,
okay.
yeah.
Okay, just give me the name. Who is who versus who?
This is Gider versus Lydia Hubbell.
Okay, then he filed. Okay, that's what I was asking.
But I was the
You,
appellant.
right, you appeal the lower court decision. That's, and that's,
Prohibition
okay.
against any mention of father, and what they said, and I took an excerpt
Okay.
right here. But they
So
did.
is that the Court of Appeals opinion?
Yes, and
Okay,
it's inside.
and that's what, and that's the ruling that you appeal from Judge Callaway, correct?
Yes.
Okay, then it's Dad's petition. He was the one who filed. He filed the initial. He was the one that got you in court.
Right, but he.
A court ruled. You disagreed with it. You asked Judge Callaway to look at it, and she agreed with with that opinion. And you filed with the Court of Appeals and said, "I disagree with what Callaway said." Right?
Yes, and then the Court of Appeals said they disagreed with what
Okay.
Callaway said.
All right. So
So this is what I'm saying about if you do extend the
order
order of
protection.
protection on, with a gag order. This gag order, I think, it's unconstitutional and
Okay.
unenforceable.
Now you asked about that. What does that case say? What do you want to make? What do you want me to hear from that case?
Well, I took out a little excerpt from it.
Okay.
I put the whole thing here. It talks about prior restraints,
Okay.
municipal prior restraints. But it says the prohibition against any mention of father by mother on social media would prohibit even the most benign reference to father. And the prohibition against mother discussing adult-only issues, oh, this is a different thing. But there was, I'll go ahead and read it. The prohibition against mother discussing adult-only issues with her child leaves a reasonable basis for doubt as to what topics beyond those specifically mentioned in the order mother may not discuss. Consequently, we modify the juvenile court's injunction to remove the prohibitions against 1, any reference by mother to father at all on social media, or 2, discussions of adult-only issues beyond those topics specifically referenced in the injunction. Our ruling, however, does not preclude the juvenile court from expanding its injunction in the future to cover additional topics, provided the restraints on mother are supported by adequate factual findings and are narrowly tailored to limit the prohibited speech.
Okay.
So me posting something that he filed against me that's got his name on it, because if you Google my name, one of the first things that comes up is his name on court documents. So this doesn't, it doesn't make sense. I mean, it's not hurting, if I was lying about him or defaming him in some way, that would be different, but I'm not.
Yeah.
And I think
But what is it you want me to take from that case?
to take the gag order out of the order of protection if you extend the order of protection.
From that, based on that case, right?
Yes. Because any mention at all, that's just way too broad. If you want to say, I can't lie about him, then that's not too broad. But because, well, it's not constitutionally protected. I don't want any restrictions by any court order on my speech that is constitutionally protected. And I'd like to give you a copy of this.
And you've already passed follow-up copy?
Yes.
This is-
Did I give you a copy of my, the expungements yet?
You did not. I mean, we haven't entered anything as an exhibit yet.
Okay, well, that's the expungements. I'd like to.
Sir, have you seen these?
Yeah, he's got his copy.
Sir?
Yes, yes.
The expungements, you want these to come in as exhibits as well as this court opinion?
Yes, please.
All right. All right, let me see. We've already got 3, 5, 6, 7, 8, 9, 10, 11, 13. This would be exhibit number 14 and 15. All right, you may continue.
Okay, another thing I wanted to bring to your attention is putting Delara on the order of protection. When the original order of protection was issued in 2015, Judge Philip Robinson, sorry, you're right. Judge Philip Robinson in Third Circuit Court put Delara on the order of protection. And then a year later, when it was up for renewal or modification or whatever, I hired a lawyer and it was agreed to take Delara off of it. That's what's on the 2016 order that you don't have. Well, where they took her off, but probably the 2017 order, it mentions that they took her off in 2016. So I had an attorney from 2015 till the end of the last custody modification trial. And then when I didn't have an attorney again, after I went to the school to check on Delara and give her a hug and tell her I hope she had a good time at her new school, I was arrested for that as an order of protection violation. And then father went to Judge Philip Smith in Fourth Circuit. Well, first he was filed for, it was certified special master. So the special master, Ballinger, she gave the father, she issued an order of protection in Delara's name because he said there was a restraining order keeping me 500 feet away from her, but I violated that restraining order, so Delara needed an order of protection against me. So the special master Ballinger did grant the father's request to get for a order of protection in Delara's name. And then I asked for a rehearing with Judge Philip Smith. And I had to argue pretty hard with him, and I told him that Because at first he was saying something about, well, you had an order against you, and, I've got a copy of the hearing, but what he finally decided was, and I give you a copy of his order here, he said that the allegations in the petition for orders of protection do not meet the statutory offense of stalking. So he did deny this request to put, to give Delara her own order of protection. And he told the father that the proper thing to do if I violate a restraining order is to go to the judge who wrote that restraining order or who has control of it and file a contempt petition, not to try to get an order of protection for my daughter. And also in Gail Robinson did the same thing when I was with order protection violations by posting on Facebook. Judge Gail Robinson said he could not in good conscience convict me for violating the First Amendment issues, but he did say that if there was a father wanted to, he should go to Judge Philip Robinson and file a contempt petition because I was disobeying Philip Robinson's order and let Philip Robinson handle it rather than sending it to criminal court. So that's happened more than once, so I think that that's relevant, and I think that Delara should not be put on an order of protection when there is a restraining order in effect that I have been following for years. Because I am afraid of, I don't want to cause problems with Delara. I don't want to make her dad mad and him retaliate against Delara. I think the best thing, based on the experience, they don't want me to know anything about her, so they don't want me to know if she's asking to see me or if she misses me, and I don't want to ask him. Because it's not gonna make any difference, because we had teachers and counselors and visitation supervisors coming in, had the school psychologist coming in, people saying how much Delara wanted to see me more, and his answer was to cut me off 100% from her. So he doesn't want me to have any contact with Delara, and this has really been hard on me to be cut off from my daughter when I have never harmed her, nor have I endangered her in any way. But that's the situation I'm in, is I think my daughter's, until I get more information, I'm not gonna try to make contact with her, but when my probation expires, I do intend to tell my story, because I think the public needs to know how the family court system is failing children and failing parents. And I think I'm going to be doing some lobbying with, I have in the past, but the people need to know how the children are falling through the cracks. And this adversarial system is just, I don't know what the answer is, but I know that ever since I conceived my child, I wanted her to have close and loving relationships with both parents, and she had that until her father decided she was old enough that she didn't need her mother anymore. And I spent years fighting to be in her life, and then when her dad started getting violent with her, I decided maybe the best thing to do is just let him have his way and keep her from being, fought over like two dogs fighting over a piece of meat. I'm not gonna do that. I'm not gonna throw dirt at him and make him out to be some kind of a monster, because he's not. I think I always had very good things to say about him, and I I want my daughter to love him, and when she was mad at him, I tried to encourage her to appreciate him and love him, and I think they probably do have a close relationship, and I don't want to interfere in that in any way. But, I don't think that, I think that she should be free to contact me if she wants to. And, I'm not planning on reaching out to her, but I don't think she should be on an order of protection, because order of protections go both ways. And I really don't think there's any legal argument for putting her on one at this point, because when Sanan went in 2017 or whatever, Judge Philip Robinson refused to put it back on it, but he did do that restraining order and sent it over here to be, I think he finally figured out juvenile court could probably do a better job of figuring out what was, what the story was. So I think that's everything I have to say. And if Dolores' dad has anything he wants to ask me or anything he wants to set straight, let me look through my list right now. Okay, so I'm saying, I think the order of protection doesn't need to be in place because I don't want to have any contact with him anyway. If you do, but you do have the authority to do it for up to 10 years. So if you do it, I think you should do it only for 4 years, because I don't think it should be in place after Laura turns 18, because I'm not going to have any contact with him anyway. And there are burdens connected with having orders of protection over you that, I would like to not have that hanging over my head. Delara can get her own order of protection. If Delara needs an order of protection, she can get one after she turns 18, or if he wants to bring her in and let her testify to you about how she feels stopped or harassed or how she wants one. She's 14 years old. I expect she's pretty articulate. So if she wants protection from me, and then I did subpoena her to court. I subpoenaed her because if she feels like she needs protection from me, I think she should be able to tell me that. And I wouldn't be mad at her, but I want to know how she feels. And I don't think people should be putting restrictions on her without her having any input. Being 14 years old, and her dad probably didn't want to bring her in because she might say she wants to see me, and he doesn't want to get into that. But that's not why we're here today. I'm not asking for any parenting time. I don't want any more, I don't want her put on this order of protection. I want the gag order to go away because it is unconstitutional and unenforceable, and other judges have said that, and the Court of Appeals judges have said that. It's got to be narrowly tailored. If you've got to put some gag order in there, it needs to be narrowly tailored for a specific purpose and not infringe on my free speech. Okay. I think that's it. That's all the case I have to make, and I think I got all the relevant evidence and stuff. And one other thing was when we were in front of Judge Gail Robinson, and Sanan was complaining about my Facebook posts. Sanan at that time said he checked my Facebook every day, and he felt harassed because I was sharing things about our court case. And Judge Robinson said that it sounded, when he's going to my Facebook page every day looking for things that he doesn't like, that's more like he's stalking me, because I'm not reaching out to him. I'm not posting on his Facebook page. I'm just sharing my story, which I believe I have a right to share. And I do complain about the court and things that have really gone wrong, but I feel like I have a right to complain. So anyway, that's all I have to say. So if he wants me to clear anything up, I think.
All right. Do you have any questions for him, sir?
I have questions for her, Your Honor.
Okay.
Ms. Hubbell, do you know what this document is?
these are like the orders for my probation. The two charges for going to check on, doing my welfare check on Delara that I ended up agreeing to, and I did agree to follow the gag order for 2 years as a condition of my probation. That's, yeah, but
For the record, would you read the special conditions for your probation?
I will, but I don't know, I agree to it. So, okay, first one, special conditions. Defendant must comply with all conditions of the order of protection entered August 31st, 2017 by Third Circuit Court, prohibiting all contact with Hubbell-Gider or reference to Hubbell-Gider in all social media, including but not limited to Facebook. Defendant is to receive a mental health assessment at Centerstone and follow any treatment recommendations. Defendant may not visit the home or property of Hubbell-Gider. Total length of probation is 2 years. 2 years. So it's 2 11-month, 29-day periods of probation running consecutively. So those are for the two. Yeah. So that's what I agreed to, and that's what I've been complying with since June of 2021. I think this is how.
I would like this to be part of the record, Your Honor, as an exhibit.
I have no objection.
Thank you.
We'd have, I think that'd be 16, I believe. This is your conviction on the violation of the order
I
of
pled
protection.
guilty to those, to 2 of the 4. They dropped the other 2, and the 3 the 3 other ones that were pending.
Go ahead, sir.
Ms. Hubbell, do you remember when we were here on September 8th, you said there is no need for child to be under order of protection because you will let her and the father alone until child turns 18. Do you remember saying that?
I don't remember saying that, but if I did say that, I would qualify that by saying, unless I get new information, that, but I don't have any, contacting you, no, I don't have any contacts, the only one to talk to you today, answering your questions.
I just need you to answer this question.
Okay,
We don't need the commentary.
As I remember, you said there is no need for child to be under order of protection because you will not make any contact with the child and leave her alone until she turns 18. That's what I remember.
Well,
Okay.
I remember saying I plan on following that restraining order, which I have been following,
Would you?
which keeps me from, 50 feet away from or no contact with her.
Is this one of your Facebook posts from September 9, the day after we were here?
Yeah.
Would you read this part, like from here down?
It says, everybody who cares about liberty, justice, free speech, family integrity, judicial accountability, etc. needs to start looking into my case and following it now. The more they get away with these abuses, the easier and more common they will become. I thought I was going to lay low and bide my time for the next 4 years until she turns 18, but this new information and lack of any information that would indicate that my daughter does not want to be free to contact me is leading me back into this fight. I've picked up the rope in this tug of war for liberty over oppression and tyranny. I said, I am still bound by the restraining order and order of protection, but the rest of you are free. Maybe Delara will be too, sooner rather than later. I still haven't picked the rope up again over her. There really isn't anything else I can do in that case. But if they file something else against me, I will have to rise to their challenge.
I would like this to be an exhibit, Your Honor.
That would be, I believe, 17, I believe. Hold on just a minute. you read the highlighted, what, you read the
I read
highlighted,
from the highlighted all the way down to the bottom.
where it starts with everybody who cares about liberty.
Yes, that's where I started reading. And I read all the way to the bottom, including the part that he did not highlight because that was relevant.
Okay, go ahead, sir.
Do you know what this document is, your Ms. Hubbell?
I do know what this is. This is a copy of the background check I took when I was applied to some, I don't know if it was DoorDash or Lyft or something, but it's a copy of the background check.
What items do you see on that background check?
I see a misdemeanor order protection violation, disposition not available, let's see, file date, October 31, let's see, October 31, 2018, general sessions court, order protection violation, misdemeanor, disposition not available. October 31, 2018, resist arrest misdemeanor dismissed. Order protection violation, general sessions, May 3rd, 2018, file date. Order protection violation misdemeanor, offense date, April 20, 2018, dismissed. Assault, domestic fear, bodily injury. Offense date, May 31st, 2015, not guilty. Charge amended from criminal trespass, aggravated home school misdemeanor, May 31st, 2015, deferred judgment. My driver's license, valid driver's license, motor vehicle report, license expired June 2024, accidents, property damage, accident, damage accident crash report, September 10, 2016. Restrictions, corrective lenses.
Did you see any item listed as existence of an order of protection by itself on the background check?
Not by itself, but you have to have an order of protection in place before you can violate it.
Do you remember testifying here when we were here on September 8th saying that you oppose the renewal of order of protection because it prevents you from getting employment? Do you remember saying that?
Something to that effect. That's one of the negatives of having an order of protection and having people think you're dangerous.
But it is not on your background check, right?
Well, like I said, when you violate an order of protection, you have to have an order of protection in place for you to violate.
Yeah, they are listing the violations, not the existing. Like
Right.
if you don't violate the order of protection, it won't show up on the background check. It looks like.
I don't see it separately listed on here, but, you know.
So we can.
As long
Oh,
as
wait,
there's
wait,
order of protection.
don't
in-
talk at the same time now.
As long as there's an order of protection that I can be arrested on bogus charges for, like, just because somebody believes I was somewhere around them, I think it's, there could be violations on there for things that I didn't do, so I think it's relevant, and I think it's dangerous for people to have unnecessary orders of protection against them.
Is this one of your Facebook posts?
Looks like it.
Would you read the date on it, please?
April 6, 2019.
Will you read the post, please?
Says this is from the background check Postmates did. I don't know if I quote passed. This is disturbing. Stuff shows up even when you have been acquitted, question mark. The October 31 arrest is still pending. As far as the car wreck, someone ran a stop sign and hit the side of my car. This sounds like I damaged somebody else's. Grubhub did not have a problem with my background check. I don't think it showed so much. I don't like this. I think if I paid some money, the deferred judgment would be expunged. Man, I would not care about this except if it kept me from getting a job. It does keep me from getting if it does keep me from getting a job, that's grounds for a defamation lawsuit. I can't stand lawyers, and I wish the judges would stop rewarding them. When most people see that someone had to get an order of protection taken out against them, had in quotation marks, they assume the person is some kind of a threat. I don't make assumptions anymore after my experiences.
I would like this to be an exhibit, Your Honor.
Any objection, ma'am?
No.
Okay, that would be,
And
number
this was part of it.
number 18, please. Was that those records? Okay. Thank you. All right, you can proceed.
Do you remember this child came
Oh, goodness.
from H.G. Park?
I do.
Do you read what do you see on the first? I'm not gonna present the other ones.
What is the relevance?
Because you are big advocate of free speech, and you came and chalked these messages on your child's playground. Would you read some of those messages you wrote for the court, please?
I'm still confused about the relevance. Are you saying that this is not protected speech?
I'm going to ask you if it is protected speech, but I want you to read what you wrote on your child's playground in your
It
neighborhood.
says, bring Delara home, free Hubbell-Gider. Hubbell-Gider, age 8.5, has been unlawfully cut off from her mother, Lydia A. Hubbell, for 2 years. I can't read this. Did you take this picture?
Yes. I might have a color copy, but
Find her, what? I can't, I don't know, I don't think I wrote that part. Maybe it says find her on Facebook. Oh, yeah, maybe I did write that. Find me on Facebook. Please help stop the judicial corruption. I'm pretty sure that says court-ordered child abuse is it's not all on here, but I think probably says anti-American. I can't read the rest of it.
that's enough, I think. And this is
And you're saying this is not constitutionally protected speech?
your child's playground. Your child goes there every day to play with her friends, and you come and write these messages, and there's a court order for you to not do this, and you think this is still a protected speech. Your right to go there and do this, even if there is a court order for you to saying stay 500 feet away from your child.
Was my daughter there? Was she there when I wrote that?
The order says any place you believe child might be present. I can find the order.
I didn't believe she was present.
No, any, that is the playground your child goes to, and the
That's
court.
not the only place I was talking. I was talking all over town. I was not within 500 feet of Delara.
It
However,
says
she was at that time. As a matter of fact, as I recall, I specifically went there when she was in school, when I knew she would not be there. So it's not like I went there, oh, she might, it's after school, it's in the afternoon, if I go by the park, she might come by and see me. I specifically went there at a time when she would not be there.
so. You think this is your protected?
I believe this is my protected speech.
Going to your child's playground, leaving these messages.
I believe it's protected speech.
Even if there is a court order saying that you need to stay 500 feet away from your child or any place she might be present.
Like I said, I was not within 500 feet or within 500 feet of any place I thought she might be present.
Okay,
How do you know she wasn't present that day?
Because she should have been in school that time of day. I went at a time when she would not have been there. And there's no kids. Well, that's a little baby. There's no kids there, school-age kids there at the playground.
okay, this is the
So
restraining
the
order.
playground is not adjacent to the school?
No, it's not a school playground.
How far is the playground from the school?
4 or 5 miles.
Not that far.
That question is yours, it's not his.
It's a lot farther away than 500 feet, I'll tell you that.
No, but she knows child goes
It's
there,
miles.
plays in the playground, Your Honor. It is our neighborhood playground.
All right.
And this is the restraining order we are talking about, right?
Yes.
Issued by circuit court, put restrictions and... Okay, will you read this part please on page
Okay,
5?
page 5, it says it is further ordered, adjudged, and agreed that mother is hereby enjoined from coming within 500 feet of Gower Elementary, within 500 feet of any place she knows or has reason to be that the minor child Hubbell-Gider is present, and within 500 feet of father's home.
Okay, and also the judge ordered you not to, would you read the next paragraph please?
It is further ordered, adjudged, and decreed that mother is hereby enjoined from writing or posting the name of minor child in public places.
Yeah. And you violated this order because you think it is your protected free speech.
I think I have a right to write my daughter's name,
Even,
especially, yeah. I think
even
so.
though there is an order saying that
I think
don't do
so.
it. Okay.
I think Constitution trumps the judge's order. And
Was she convicted of violation of order of protection regarding those exhibits?
No, Your Honor.
Okay.
Most of her violations she never been charged with it.
Okay.
they
Yes.
was either acquitted or they were dismissed.
I mean,
Well, but-
there wasn't any.
Did she go to court on those charges?
No, Your Honor.
Yes,
Wait a minute,
yes,
why
I
not
did.
hearing
Went to,
yes?
that's-
I'm hearing yes from you and hearing no from him, so
I would have
were
to
you
go-
violated on those particular documents?
as I recall, this is one of the ones that went before Judge Gail Robinson, and that's one of the ones that ended up I was not convicted.
I never filed contempt for restraining order violations, Your Honor. So this will be a restraining order violation. So she never was charged for a restraining order violation. It will be a separate hearing. All her charges are under the order of protection
Okay.
violations.
All right.
Is there a statute of limitations on filing contempt?
Okay, we're not, you're not asking a question,
Sorry.
he's on your cross, he's doing his cross.
And when you came to your child's school, like I believe it was 2019,
19.
and this restraining order was present. Also, there was an order, no contact order from Judge Callaway saying that you should have no contact with your child and you shouldn't have any access to your child's school records, but you still go to school, right? Is that correct?
July 29th, 2019, on the open house, yes, I already testified to that.
Yeah, and there is like Judge Callaway's order, it says all contact between Dilara and her mother is suspended. This is to include contact to the phones, fans, rock calls, school visits, appointments, visit letters, any other mechanisms which will allow contact. And you still came to school to her open house, right? And you gave her a hug, you whispered her into her ear, despite this order and despite restraining order saying that you need to be 500 feet away from
I
that.
don't recall you whispering in her ear.
I remember you said something to her ear.
Did you ask her what I said? I did say something to her, but I wasn't whispering.
Yeah.
It was noisy in there.
And when you came to school, the restraining order was in place, is that right? This
Yes.
was already issued, and it's telling you need to be at least 500
Yes.
feet. Okay, so you violated that part of the
I
first.
did,
Okay.
I did, and that's, we
Wait,
approved that.
wait till he finishes his question
Okay.
before you answer, please.
And also this order from Judge Callaway from September 2018. Will you read this part, please?
What year was that order, sir?
2018 issue.
2018, it is ordered a judge to decree that all contact between Delora and her mother is suspended. This is to include contact through phones, fans, rocks, calls, school visits, appointments, visits, letters, and any other mechanism which would allow contact.
And you violated this order as well.
I did. And we went through all this in Philip Smith's courtroom.
Are you allowed to see your child's school records?
No,
Did you obtain your child's school records while there was an order telling you not to have access to your child's school records?
I subpoenaed them for a court date.
But they sent it to you, then you reviewed the child's record, even though there was an order
I did.
telling you not to
I
have any
violated,
contact.
I believe that Judge Robertson here scolded me for that.
Yeah, I'm trying to find that part of the order, Your Honor. Judge Callaway ordered her not to have any contact with the
It's
school.
right underneath the highlighted part, you just didn't highlight that too.
Oh, yes. The mother is also restrained and enjoined from having any contact with the school or receiving any of child's school documents or paperwork. And you obtain her school records in violation.
Yes.
Okay. Did you post a document with my social security number, address, phone number, employer on your Facebook post?
I-
Facebook page?
Accidentally did, and I took it down, and all my information was on that too, so I took it down for both of us.
I believe one of her asked for posting my private information, Your Honor. That
I'm sorry.
one of the, she was saying earlier that if she mentions my name, she gets arrested. That is not true, Your Honor. The one time I reported it because she had a document with my social security number, address, my previous employer's name, my birthday, and my driver license
And
number.
all my information was on that too.
And-
That was in with some other stuff,
And
but that's,
how long, Ms. Hubbell, hold on, and how long ago was that?
This was a while, but the order of protection was in place saying that she should not mention my, me on.
So this was,
I'd like to see proof
so
of
what's
that.
the date, so what's the date that she posted that information?
It is a while back ago, Your Honor.
So what?
It's been few years. It has been few years, but it was during the time of order of protection stating that mother should not mention father on social media.
well, you don't have
And
any
you,
proof of
and,
that.
and,
I
wait,
can't
wait,
prove
wait,
that.
and you admitted that you did do that, correct?
But I did, and I took it down, but I don't believe it was while this order of protection was in place. And he just said that I wasn't arrested for just posting his name. That's exactly what they told me when I posted that court document that had his name on it. They said, even posting that, that's what I was arrested for, is what they told me. So, it wasn't posting his personal, I shouldn't post his personal information, I shouldn't post my personal information, and that was an oversight, and I took it down. And as far as I know, he hasn't suffered any negative repercussions from that. I haven't, I mean, nobody's been stolen my identity or anything, so.
Did you know the Tennessee Code, Title 39, Chapter 17, Part
I can tell you, I
350?
don't.
Wait,
Right off the
wait,
top of
wait,
my
wait,
head, I
wait,
don't.
wait till he finishes the question,
Okay.
please.
Like stalking, aggravated stalking, especially aggravating stalking? Has this code ever been presented to you before? Like,
I got it right here. What part are you, yeah, I mean, when it came up in Philip Smith's courtroom, when he determined that
yes.
my behavior did not, whatever that court order says, when he denied your request.
But did he also tell you if you violate these orders, the child will be put under order of protection? Do you remember saying that? Him saying that? If you continue to violate?
I don't, I think he was going by a course of conduct, but,
Well, I'm not asking what he was
I don't-
thinking,
I-
what
I don't remember
you think he was
exactly what
thinking.
said.
All he's asked you, do you remember what the judge stated?
No, I just remember that he denied, he scolded me very severely.
Okay, just tell us what the judge said.
He said I should be following the black letter of the law, and I got off on a technicality. That's what he said. I remember him saying that.
Then after that hearing, you came to father's house how many times?
I went to your house 4 times to check
Okay,
on the
let's say
letter.
4 times. And you know the child lives there, there's a restraining order saying that you need to be away from any place. Your child might be present, and Judge Smith told you, look, if you keep doing what you are doing, your child is gonna be put under order of protection because of this Tennessee code for stalking. And you still came to my house where the child lives. Did you? Yeah, you came and you pled
That's a
guilty.
yes or no. Did you go to his house, man?
I did. I went to his house 4 times.
And do you know where your child lives in that house?
I did not know if my child was living in that house. That's why I went. I was hoping to find out if she was living in that
But
house.
as far as I know, that's the last place your
That's the
child was.
last place I knew of where she was, but I never did see her there. I never saw any sign of her there.
Okay, you violated 2 court orders, one from circuit court, another one from juvenile court, saying that you should have no contact with your child, stay at least 500 feet away from any place your child might be present, and you still come to the place you believe your child was living. Right.
Yes, and as far as I know, you have filed a contempt petition for those things that I did.
Yeah, I can file contempt petition, yes.
Well,
But also there is a Tennessee criminal code saying that the individual is qualified to be put under order of protection if there is a order saying that you need to stay away from that individual, and if you don't follow that
well,
individual.
let's go into that then. Let's go into that. We'll go through with Judge Robinson like we did with Philip Smith, and we'll see if Judge Robinson agrees with you.
What do you mean by that?
I mean, you proved to him that Philip Smith was wrong in his interpretation of stuff.
I'm not saying that.
You proved that I stalked Delara. You proved that. If you cannot prove I stalked Delara.
Let's keep to the questions that he's asking, okay? Did she respond to your question?
So there is a.
I think the question was, did you go to his house?
I went to his house 4 times to check on
All
Delara.
right. But I think, and the other question that I have, was there a violation filed?
On that order of protection,
With her going to your home?
On his order of protection, she didn't have one.
Okay, I'm not,
but
I'm just asking, did you file a violation?
yes, Your Honor, for order of protection violation, not
On
for
her coming to your home 4
Mhm.
times, and was she convicted of that?
I believe 2 of those
I have
convictions.
2. That's what I'm on probation now for.
So you were convicted of going to his home?
But violating the order of protection.
Okay, so you admit you violated it, and you have a conviction. Okay, now let's move on.
Okay, according to your opinion, there are 2 orders saying that you need to stay away from this individual, you shouldn't write her name in public places, and you go to her playground and write these messages, free Hubbell-Gider, court order child abuse, and some other things. Do you think is this stalking? According to your opinion, is this stalking?
No, it's absolutely not. It's not stalking according to the statute either.
Okay. So
Okay,
do you have a conviction for any stalking? Yes or no? Do you have any? Was she violated for stalking?
Bellinger put the child under order of protection for
Because of this alleged stalking?
Stalking, yes,
So
sir.
And
Judge
that's-
Philip Smith reversed that on the
Okay,
record.
so the special master found enough to put,
Child on.
but but when the judge heard it, he actually reversed that. Is that
Yes,
right?
Your Honor.
So I can't hear anything about that.
I
Okay.
gave you the actual
Okay.
order.
I can't hear anything about that. So
I would like
that was
this-
reversed.
I would like this to be a exhibit, Your Honor.
Which one
This
is
is
that, sir?
basically,
I object.
Which one is that, sir?
this is her chalk messages.
Shopping at the playground, that doesn't do anything to support.
Now, what was that prior to the order of protection, or was that during the order of protection?
It was,
This is not for you. This is his cross. Go ahead.
This is prior to order of protection, but there was order of protection in place when she wrote this, Your Honor.
But okay, so was she convicted of anything on that issue?
I don't recall.
Okay, well, I can't take that in. That's just okay.
Okay, then I will ask you this one.
What?
Would you like look at these text chalk messages, please?
this is the same thing as those, these chopped messages. There's no, he had me arrested for these.
Are these your chalk messages?
I don't really recognize that one or this one, but I've done a lot of talkings, but I object to these being brought up because
Let me ask you this. I don't know, Mr. Gider, were these during the order of protection? Was she convicted on these?
Yes, Your Honor. She
Okay.
was charged, but I'm not sure if it was part of her plea deal, and she came and chalked these messages when there was an order of protection and also there was a restraining order.
Now,
And
do you have the date of those chart of those pictures there, sir?
Here I found one, Your Honor, from September 2019.
Okay. Now, we have two guilty pleas on the order of protection dated 2020, June of 2021. But you don't know if those pictures were included as part of her conviction, do you?
I don't know what, there were 7 charges. One of the 7 charges was writing these messages in the playground we go to play.
Your Honor, the thing.
Now, okay, let me just go back. What's the date of those pictures again?
The one I have is from her Facebook post. She posted one of her chalk messages. It's
Okay, what's the date of this?
September 19, 2019.
September 2019?
Yes.
So the order of protection was entered in August of 2017 by Third Circuit, and that's the one that came into exhibit. It prohibited all contact with you or reference to you in all social media, but not limited to Facebook. Defendant may
Okay,
not
these
visit the
are-
home.
Your Honor, these are from October 2018.
2018.
Mm-hmm.
So that was probably part of this order of protection that she violated. Okay. Okay. All right.
I was arrested with no convictions.
So, do you remember this? Is it one of your chalkings?
It looks like one of my chalkings.
Do you remember where it was?
No, off the top of my head, it looks like a park.
This is another chalking of Your Honor.
Do you know the date of those? Was that
Yes, it is from October 2018.
2018.
October.
Do you know the disposition of those charges, Ms. Hubbell?
I believe that this is one of the 3 that,
Did you plead guilty to that?
no, I did not. Those are, supposed to go away with my probation. That's the plea deal. I had two trials pending, plus I had these 40 charges for going to her house, and they dismissed those.
They dismissed those?
Well,
Or
yes.
did you do
If I violate my probation, he
or
gave
did
me
you
my.
do a plea?
No, I'm not gonna plead guilty.
I'm just asking. I'm asking.
No, I did plead guilty to going to her house, violating the order of protection by going to her house. I never pled guilty by any kind of
Mhm.
chalking or posting on Facebook. I did not. no judge, been arrested plenty of times and spent plenty of days in jail that I haven't, nobody's ever convicted me of that, and I don't believe it could.
Do you have the order of protection from August of 2017? Because I want to look at those conditions that were placed.
Yes, I have it, Your Honor.
Let me pass it up a minute.
This is the renewal for 5 years.
Now, those sidewalks, are those pictures there of the
It's
sidewalk?
like a public park.
Okay, well, it's on the sidewalk, right?
Mm-hmm.
Okay. Well,
Graham,
okay, according to this, this order from Judge Robinson, you admitted that you encourage others to use sidewalk chalk and to write messages about custody cases involving the father and the daughter. Mother admitted that she has a hashtag bring Darla home, and she writes on sidewalks. Mother admitted that she used sidewalk chalk to write messages all over the city, including around playgrounds where she knows her daughter used to play, and outside the father's neighborhood, because mother wants her daughter to know that she's still trying to get her back. So you admitted to that.
I chopped all over town, yeah.
Yeah.
But I'm not saying that this is, I don't believe that, I believe this is constitutionally.
But it doesn't matter what
protected
you
speech.
believe. I'm just saying what you admitted to, and
I
this,
did,
and
I
this
chopped
part.
all over town, and I read
Okay,
my daughter's name.
but you've already admitted to that in this document, and this was signed in August of 2017. Okay. And that was the one that extended the order of protection to June to 5 years, 2016 to 5 years. Okay. So that's already been admitted to. You already admitted to that. Regardless of what you feel about being constitutionally protected, you already admitted. And you found in violation of the order of protection because of your admittance.
No judge has found me, or jury, no judge or jury has convicted me of being in violation of the order of protection. This is like what, these and the Facebook posts, those are what have not, the DA has thrown them out, or I've been acquitted. And this is something that I've challenged, and so far they haven't.
Well, I
had any
mean,
conviction.
the order is very clear, ma'am. The judge found you guilty of you violating the order of protection.
That's not a criminal offense. He said the
It
standard of
is.
proof was lower.
It's. Well, I'm
He
not.
said-
I'm not necessarily, since you're representing yourself. I mean, you're still held to the same standard as an attorney, but this is the judge's ruling, and he found you in violation of the order of protection.
That's a finding. That is not a criminal conviction.
Ma'am, well, I'm gonna let you go, but with that, if you think that's correct, but I'm sitting here as the trial of the fact, and yes, this does carry criminal implications to it. But I'm not here to coach you on the law, but it's a criminal conviction, and Okay. Go ahead, sir.
So do you admit that is one of your child messages?
It looks like it might be.
And also you posted this on Facebook. Can you guess where with a child message from?
I don't know where that is, I don't.
Yeah,
I chalked, after being told not to, I chalked.
yeah. The judge told you not to
And
chalk
I
your
did it
child.
anyway.
Yeah, you did it anyway. Because it is your protected speech, right? Going to your child's playground, riding.
All over town, and then
Court-related
other
messages.
counties too. I've done it in
Nope,
other counties
just
too.
one speaking at a time, please.
And once your probation is over, do you think you will continue to with your
When
activities?
my probation is over, I probably won't write her name down because I don't, there's just been so much, I'll write my name down.
Do you think it will stresses your child? Like she goes to play with her
I
friends.
have no idea, I'm not gonna speculate about that. If you think
Wait. Just wait until you finish the question before you answer. Please, one speaking at a time.
Like this is from you started doing this in 2018, 19. Your child was around 11 years old, or 10 years old. Yeah, like she's like 10 years old. She's going to playground to play with her friends, and she's seeing all these messages everywhere, like free Hubbell-Gider, court order, child abuse. Have you ever thought this might stress your child?
No.
No, you don't think it will stress
Based
her.
on what she said to me about those, it did not stress her. In fact, she encouraged me.
And that is,
She encouraged me. She was glad I was doing it. It's what she told me.
and you think that's good for your child's psychology, seeing her name written all over.
I think
Okay.
I think it's good for her to know she's got somebody in her corner and trying to support her. You haven't presented any evidence, any hard evidence other than what you say. It's not good for her. You never brought her in and let her speak for herself. And she never said anything to me about it after I was doing it. She'd seen it. She was excited about it. She was thankful for it. She wanted me to keep doing it. And she said, if I ever see you out holding a sign, I'll run up to you and hug you for it. That's what she told me.
And you came to your child's school on the first day of school with your signs at,
That was back 2017, and that's not relevant. That was not a violation of, that was before the order protection, all those other conditions on the order protection, so that's not relevant.
and this is a Facebook post, right, from you?
Yeah, it looks like a Facebook post. Oh, wow! You already got that? You're still stalking my Facebook page every day?
Let's
Dang.
just answer the
I
question.
just posted that.
How
When did
long
I post
ago
it?
was this
Last
post?
night?
Yeah, you posted last night.
9 hours?
Stop. Answer the question, please.
Gosh, yeah, let me read it. I am a warrior for free speech. I am a warrior for parental rights. I don't believe you should give in to bullies or negotiate with terrorists. I believe that there is a way to make sure judges are unlikely to deliberately abuse their discretion. I believe that the Supreme Court of Tennessee should be an error-correcting court. Maybe somebody can persuade me to change my position. All I know is somebody needs to be able to review Court of Appeals cases. Something is very wrong. Maybe my last case was an anomaly, but I think it is probably not. There was nothing in the opinion in my last case to indicate that my brief was read and the record for appeal reviewed. There were several comments made that indicate to me that they weren't. Court in the morning to try to stop this 10-year order protection. If granted at all, it should expire when Delara turns 18. It also should not contain a gag order, and Delara should not be put on it. 9 hours.
And you say negotiate with, don't give in to bullies, negotiate with terrorists.
I don't believe you should give in to bullies or negotiate with terrorists. That's one of my maxims.
Who are the terrorists?
They're all over the world, everywhere. Terrorists are people who try to control you through fear and intimidate you. That's my definition for a terrorist.
Do you think courts are terrorists in your
Uh,
or judges?
um, I wasn't referring to, no, that's not what I was referring to in that.
So who are the terrorists in your case? Is it me?
I think you have tried to intimidate me with fear before, control me with fear. You've threatened my life. You threatened to kill my son. I think that's. I do feel terror. I have had PTSD type symptoms from things you have put me through in the last 8 years, and I've had to go on medication for them, and I feel like I've been terrorized by things you've done. And I'm glad I've had the strength to stand up to you and not be intimidated by you. But a lot of people are, and, you know.
But court is the one who is holding you back, right? They are limiting
You're the
your
one that's
first.
asking.
But
You're
they
the one
are
that's petitioning the court, and I do hold the court ultimately responsible. And I think you're just sick in the head. I don't think you can help what you're doing, but I think every time you get your way, I think it makes you a little bit sicker. I think it's a sad situation. I feel sorry for you. But I still don't think, I don't think you should be intimidated I don't think you should be intimidated out of things that are put in place to protect you and to encourage your well-being. Bullies, they're trying to take things away from you that they don't have a right to. They're trying to make you live in fear. I think people should stand up to bullies. I'll stand by that statement. So I don't know why you have a problem with my personal moral values. I don't think you should give in to bullies either.
Well, I care if I go to take my child to my playground and if my name or my...
You're testifying. You just need to ask her a question. Just ask her a question.
Okay. I would like this post to be an exhibit, Your Honor. She is referring to saying
Your Honor, I object to being, I believe it's totally irrelevant.
Okay. Objection noted.
Also, these two, one is Facebook post with a child message with child's name. This is posted after the restraining order was issued by circuit court saying that she shouldn't write child's name. It is a violation. And also a child message, I took the picture from 2018. 2 exhibits, Your Honor, and she was charged for these.
Sure.
I object to those being admitted because those have already been dealt with in other courts.
Well,
I still believe that's constitutionally protected speech.
oh,
And I believe they would be properly admitted in a timely filed contempt petition.
I have no further questions, Your Honor.
so 19 and 20 are being admitted over your objection, ma'am. So I will note your objection. Okay. It shifts back to you, ma'am. Do you have any redirect or?
No, I don't. I think I've said everything I need to say.
Then I'll take a brief break and we'll come back. And you closed all your proofs, correct, sir?
Yes, Your Honor.
All right, we'll come back and we'll have closing arguments. Give me about 10 minutes, okay? Do not speak to anyone outside about this case or any telephone calls about this, to anybody about this case, okay? Get my paperwork together, I'll be ready. All right. We'll take about 10 minutes.
We'll be in recess for 10 minutes. Court is back in session. You may keep your seats.
We'll start with you, Mr. Gider, with your closing statements, rather.
Your Honor, as my motion stated, I would like my order of protection to be extended for 10 years, and I would like child to be placed under order of protection. The reason being, Mother Miss Hubbell violated both orders, my order of protection and the restraining order that protects child, and also there is an order from juvenile court that enjoins Miss Hubbell from making any contact with the child. And Miss Hubbell admitted during her testimony she violated those orders by coming to child's school, by coming to father's house multiple times where child lives. She sent child to letters, postcards. Her YouTube videos are still online, and TikTok videos are still online. She's addressing the child, and I believe these are continuous violations, even though Judge Callaway's order states that she should not have any contact with the child, no letter, no writing, no messages, and those videos are still online. And she also accessed child's school record in violation of the Judge Callaway's order. And child is getting old. She will probably want to have a part-time job, so I would feel a lot better if child is protected with an order of protection because of Miss Hubbell's past violations. She is currently on some kind of medication. I'm not sure if she is on medication because of her probation, because the probation states that she needs to follow, get a mental health assessment and follow the recommendation of doctors. So considering Miss Hubbell's past history of violations and what she said, she believes she is not a stalker, even though there is an order saying that you need to stay away from your child, and she's still violating, and she thinks those orders are unconstitutional. And Tennessee Code 39-17-315 explicitly states at the time of the offense was prohibited from making contact with the victim under a restraining order or injunction for protection, an order of protection, and it goes on. Then it stays under H. Any person who reasonably believes they are a victim of an offense under this section, regardless of whether the alleged perpetrator has been arrested, charged, or convicted of stalking-related offense, shall be entitled to seek and obtain an order of protection in the same manner and under the same circumstances as provided for victims of domestic abuse by Title 36, Chapter 3, Part 6. So, Ms. Hubbell's violations meet this code, and child, I believe, entitles, deserves, and need an order of protection, Your Honor. And as a parent, it will put me a lot ease if you issue the order. Thank you.
Thank you. Mom?
I don't have a closing argument.
I do have a question for you, Ms. Hubbell. Get to it real quick. Part of your plea on the in the criminal court on the violations of OP state that you are to comply with all the conditions of the August 31st order in Third Circuit, but it also states that you are to receive a mental health assessment from Centerstone. What's the status of your mental health assessment?
I had that. That's one of the first things I did. I've had so many mental health evaluations, and I've got.
Well, I just asked about the status of the one that was ordered on.
Yeah, that's been done.
Well, when was it done?
I don't have it on hand. My probation officer's got it in their file though.
But you, I mean, That's something you would have to have in your own file because that's something you have to show the court.
I didn't bring it. I have to show the court that? I thought
If-
my probation officer, nobody's asked me for it. If you'd asked me for it,
Well, again, if you did
and
it,
I didn't get a copy of the assessment.
well, you typically, the assessment is shared with the patient. I mean, that's just, if you don't get a copy of it, how do you know what the recommendations are?
There weren't any recommendations.
Well, how do you know you were there if you
Well,
didn't get a copy?
I sat down there with the person and.
But the person actually, once they do the assessment, they come back with a written report. And the written report will state the conclusions from the
Well, I didn't
assessment.
get a copy of that one. I got a copy of one, who was the other one? From Athena Consulting that DCS had me take.
Well, that was, but I'm looking at the one from the OP. So you're saying you
I
didn't,
have the assessment at Centerstone, but it's been like a year and a half ago. I got it right away.
a year and a half, that's pretty,
I got it right away after my probation stuff. Maybe not a year and a half, maybe a year.
okay. So now you're saying you did get it.
I did go to Centerstone and get yeah, and I got a few weeks of counseling with it from,
So what did it say? What,
they didn't send me a copy of it.
well, you just said you got a copy.
They did one. They
Okay.
did one.
Okay.
But I don't, and I told them to send it to the probation people. So I don't know if you need me to.
So you weren't curious as to what the assessment?
No, because they didn't, I think they would tell me if.
Well, they would tell you, but
They
they
didn't.
normally do it in a written report because the court order says you to follow any recommendations from the report. So you're saying you didn't get it. How do you know if there were any recommendations or not?
I don't know. I
What,
can talk
what,
to my probation officer and see where it is.
that's very odd.
Nobody said, because they know I'm doing what I need to be doing for my mental health. It's when I sit down and talk to them.
Who knows that?
The mental health professionals that are sitting down and talking to me and hearing everything I'm going through.
Okay.
And
How often do you go to mental health counseling?
I'm not going anymore. I'm seeing my regular since
But that's
this
what I
started.
said. Now you
They
just
didn't say, nobody told me I have to go.
you
see
just
therapist
contradicted
online.
yourself because you said when I sat down and talked to all my counselors, they said I'm doing good. So how often are you going to this?
I haven't been in a while. My therapist moved. I haven't been to counseling in a while because it's really not beneficial and it costs money and I can't afford it and that stresses me out worse.
So you're not
I'm just kind of biding my time.
So you're not getting any type of counseling then.
Not professional counseling, but I am talking. My regular doctors got me on a prescription for anxiety and depression. And I talked to her about what's going on. I mean, my mental health is my number one priority.
How do you see your probation officer?
Not very often.
When was the last time you seen your probation officer?
A couple of months ago, I guess.
I mean,
maybe 2 months ago. I'm one of their low people that don't need a lot of, you know, I don't know, remember what they call it, but they evaluate you to figure out how much oversight and stuff they think you need, and apparently they don't think I need a lot. I'm just being,
When is your next appointment?
I don't have one set up yet. I guess they'll call me.
So in your last appointment, did they set it up at your prior appointment, or did they have to call you in, or what? How does it
I
work?
went in to get a travel permit and got a drug test, a travel permit.
To travel out of the county, or
Yeah, out of the state.
that's one of your terms of your probation?
Get a travel permit if I go out of, yeah.
That's one of your terms. That's one of the probation terms.
When you're on,
But I'm just
I-
asking. It varies, it varies. So,
they told me I had to get a drug
Okay.
test and a travel permit.
and what else? What other conditions that you have to comply with?
I need to pay some fines, and they do home visits every once in a while and make sure I live where I say I live.
When was the last time they did a home visit?
Oh, it's been several months. I don't keep track of everything.
So when you go in for your checkups, where do you go?
I don't go in for anything on a regular basis. There's a place, I think it's on White Avenue, the office.
Okay, when you went there last time to get your passport,
For
to get
travel?
your travel, where did you go?
To White Avenue.
White Avenue? Is that where you've been going since you've been on probation?
Mm-hmm. I've changed probation officers about 4 times. I've had like three different probation officers, I guess.
On these complicated cases, typically I don't issue rulings from the court. I take all the evidence and testimony under advisement and issue a written ruling. And in this case, I would have a written ruling probably within 20 days based on my court calendar for the rest of the month. So, but in any event, the prior order stays in effect. All conditions of the prior order remain as previously ordered. No change as of today.
Thank you, Your Honor.
And I'll put that in a decree sheet for you today, so you'll have that. And we'll issue a written ruling. Now let me just, are y'all's addresses still the same as previously?
Mine is.
Mine is too.
All right, get that out to you all. And let me finish this decree sheet. Don't leave until you get a copy of this decree sheet for today. Let me finish it up. You step outside unless you have any questions. Any questions?
No, Your Honor.
All right, thank y'all.
Thank you.
Do you need me to get you a copy of my Centerstone evaluation thing?
No, I was curious if you had it, but that's part of
No.
your probation.
Well,
That order is still in effect.
Yeah.
Thank you, ma'am. Thank you, sir. And thank you.
Oh, thank you, I appreciate it.